never intended to be. In 370, when it was put in, it had to be a temporary provision. It had to be, Malad. There was nothing there at that point in time. It had to be, Malad. It could never be a permanent thing.
Well, why did the Constitution then put it in Part 21?
Because, Malad, it is a separate, it relates to a particular state where the two sovereigns have come together and made a compact which is incorporated and integrated.
The reason why it refers, Clause 3 refers to the Constituent Assembly of the state referred to in Clause 2 is because Clause 2 refers to the Constituent Assembly for the purpose of framing the Constitution.
That's correct. That's exactly
right?
why
That's your point. You get that point?
Yeah.
Now, therefore, the recommendation of which Constituent Assembly, this makes it very clear that one and only Constituent Assembly which was formed for the purpose of framing of the state constitution.
Right.
Once the frame of the constitution was done, then that purpose of the Constituent Assembly is not like a permanent body. Like Parliament is a permanent body. The Supreme Court is a permanent body.
No doubt about it.
It's a body which has a specific purpose and then after it becomes functus officio, so to speak.
Right.
Therefore, once the Constituent Assembly had fulfilled its purpose, then the proviso itself has no application.
No, this is the problem, Malaj, with the problem there is when you are applying 3 without the proviso and saying this is a blanket power, then it's then Malaj, the president can do it anytime without any consultation.
One thing which we must
just passes an order.
Mr.
That I integrate. That's
one thing which we have to also bear in mind is all these provisions are in Part 21. Part 21 has used 3 expressions: temporary, transitional, and special.
Correct.
Temporary provisions are those which are intended to be in existence for a limited period of time,
That's right.
but without a point of terminus, right? A temporary government servant. That person is temporary for a limited period of time, but whose services are to be terminated. Until you are terminating the services of that person still continues.
Right.
That's that broad concept, of temporary.
Absolutely right.
Transitional means something which necessarily has a terminus.
That's right.
Laws made
earlier.
I'll show you some of the transitional provisions in this part.
Right.
And third is special.
Right.
Now we'll see, for instance, after 370, we'll get some idea from the provisions after 370. Say 371, special provision with respect to Maharashtra and Gujarat. 371A, special provision for Nagaland.
Yes.
Then we get 371B, special provision for Assam.
Correct.
371C, special provision for Manipur.
That's correct.
D, for the state of Andhra Pradesh and Telangana.
Right.
E, establishment of Central University in AP. F is special provision for Sikkim, which came in 75.
Right.
G, Mizoram. H, special provision for Arunachal.
Yes.
Then I for state of Goa. J for the state of Karnataka.
Right.
Now, after these special provisions end, we come to 372.
Right.
Which continuance in force of existing laws.
Yes.
Which then says, shall continue in force until altered or repealed or amended by a competent legislature or by any other, like the penal code.
Right.
It just continued in force until it is altered. Then similarly, now we have 372A, power of the president to adapt laws.
Right.
And it says the president may by order made before the 1st of November 1957 make such adaptations and modifications.
Right.
So this was a transitional provision that the president had to make those adaptations by the 1st of November 1957. So it was a transitional provision. After that, the power lapses. So similarly, 373, was then came the provisions relating to the judges whose services had to be taken over by the Union of India, public service commissions, so on and so forth. And then 392, the power of the president to remove difficulties.
Right.
So therefore, Part 21 basically covers special provisions, temporary provisions, and transitional provisions.
Right.
Now, it doesn't use the expression transitional in any head note or marginal note to the articles. But temporary and special are used in the marginal notes to specific articles of Part 21. And 370 specifically uses the expression temporary.
It had to, Malaj.
So, can we then by saying that the power under clause 3 goes once the Constituent Assembly comes to an end, really convert this into a permanent provision, which it was never intended to be by the
But
Constitution.
that's your lordships are now putting to me, it was never intended to be. In 370, when it was put in, it had to be a temporary provision. It had to be, Malad. There was nothing there at that point in time. It had to be, Malad. It could never be a permanent thing.
So why did the Constitution then put it in part 21?
Because, Malad, it is a separate, it relates to a particular state where the two sovereigns have come together and made a compact which is incorporated and integrated.
No, part 21 does not deal only with Kashmir. Doesn't deal only with Jammu and Kashmir. It deals with other states also.
I'm sorry, I didn't get.
Part 21
Yes.
does not deal only with Jammu and Kashmir.
No, of course not. That's what I think is a separate independent provision and has to be interpreted on its own terms. You can't incorporate Muller's concepts outside of 370 and integrate them into 370 and say, this is how we'll read 370. Yes. 370 is not temporary. 370 is not temporary.
General note expressly says it's temporary.
No, it says temporary provisions with respect to temporary provisions. In other words, this is a provision which is temporary till such time as the Constituent Assembly decides this way or that way. That's the whole purpose, Malad. Because when the Constitution came into force, there was no such thing as the Constituent Assembly even. How did the Constitution add this here? Because there was an understanding. Otherwise, why would you bring in the term Constituent Assembly in 370? It was not anywhere else. Temporary, supposing, Malad, not that I should say so, because one never knows. Supposing the Constituent Assembly decided not to be with India, then what happens? We would have to do what we did to Junagadh.
You know, there are two types of temporary provisions in part 21. One type is Article 369. 369 says Parliament had the power to make laws for a period of 5 years.
That's correct.
On certain matters, even if they may not be in the concurrent.
Absolutely, yes.
So they were temporary with reference to time. They were temporal.
I agree.
Then 370 is an illustration of a case which is temporary in the sense it will operate till abrogated. Would it be? I mean, we're just when Mr.
Not
Sibal,
till abrogated.
when we are putting your point, it's actually we are thinking
I
that
understand.
we're just.
I understand, Malad. This is your lordships have always done this, Malad. Your lordships. This is a very fruitful debate because we all have to understand. We are here standing
it's only in
for
that
India.
process that
We're
we can
standing for
really.
the people of India. We're not, Malad. This is not something that we believe we are totally integrated into India. That's not an issue, Malad. We have said so. Therefore, there is no, as far as, I mean, our constitution says we are an integral part of India. So where's the question of moving away from that? There were only two choices, Malad. So we said, the Constituency Assembly said all of constitution to apply. We'd be like any other state.
But they don't have to make a constitution of their own.
Then they don't have to make a constitution of their own.
Indian constitution applies.
One second. They don't have to make a constitution of their own. The Constituent Assembly would say, we integrate into India, we're part of India, we're like any other state, we don't need a constitution, and all those lists will apply. That power is there. So why was it called a temporary provision? Because that had to be decided by the Constituent Assembly. And then you interpret the terms to find out how that power is to be exercised. Because it was unlike any other state. The residuary power was always with the state.